You will have 15 minutes to present your argument, and I want to make sure that I also go through our litany of things you are not to do, and that is not to mention the names of any minors, not to mention the names of any victims, and we are ready.
Thank you, Your Honors. May it please the Court, my name is Joe Connick. I'm here on behalf of the appellant, Mr. Michael McGee. We're here on one assignment of error. The trial court erred and abused its discretion, denying the appellant's motion to dismiss or in the alternative transfer the case to arbitration because the claims and allegations that the appellee claimed or complaint were bound by a valid and binding arbitration agreement. This matter arose out of a landlord-tenant dispute where between the appellee and the appellant. The appellee was under a 30-day or a month-to-month lease, and my client gave her a 30-day notice to vacate the premises so he could make significant repairs on his property. Now, in her complaint, she's claiming all these other retaliation damages, throwing out her goods and things of the like, but the sole purpose of this appeal is trial court erred in denying our motion to dismiss or in the alternative transfer arbitration.
Did the trial court have a hearing on that motion to compel arbitration?
They did not.
So there was just a summary denial?
Yes. And
Well, since Judge Lanzinger has asked that question, I'll go ahead and start with one that's been on my mind. In reading the court's entry, the court, an argument could be made, the court did not, in essence, deny your motion because the court said it's premature. So the court didn't say, I won't consider this in the future, but I want you to go to mediation first.
correct. And that goes back to my next point is we attempted to engage in mediation talks with the appellee, and she simply failed to engage in the online dispute resolution, ODR, with the court.
But I don't know if that's going to be on the record, number one, and we can only consider things that are in the record. But the court did have a date set for the mediation, right?
Correct. May 1st it had to be completed by, and we filed this motion on April 12th because we were under the impression that she was not going to engage in the mediation. And first, we believe that the court they lacked subject matter jurisdiction in the first place because there was a mandatory arbitration provision that controlled all the claims that arose out of the lease agreement in this case. And Ohio courts and strong Ohio public policy favor arbitration at the very outset of the case. Especially in an instance in like this case where it arose out of a small claims issue, going to arbitration instead of litigation should have been favored by the trial court because the damages are capped at $6,000, but yet here we are litigating this case in the Court of Appeals when this could have already just been directly sent to arbitration under the arbitration provision.
Is arbitration even valid in foreclosure, not foreclosures, in evictions?
Yeah, there's in the lease agreements, in landlord lease agreements, they're quite often, and they're quite expected to have arbitration agreements in the lease agreement.
So you can circumvent the Ohio statutory law that requires landlords to do all these different things just by having an arbitration provision in a lease agreement.
I believe so.
I'm sorry, Judge.
There were some exceptions in your arbitration clause though for eviction and
Yeah, well, technically,
back rent.
technically, he didn't evict her. He gave her a 30-day notice to move out of the property, which he has every right to do because it's his property, and under the required Ohio law, he gave proper a 30-day notice on a month-to-month tenant. And going back to my point, in this case, the appellee, she signed the lease agreement, and in the lease agreement, the arbitration provision is on its separate page, on the last page, and it's directly above where she signed. And Ms. Turner, the appellee, made no assertion that this was an unenforceable arbitration provision, that she was fraudulently induced into signing the lease agreement. She didn't reply to our motion. She didn't file a merit brief, which further enhances her agreement to arbitrate all claims under the lease agreement. Had she wanted to argue that the arbitration provision should be unenforceable, she could have made those arguments in a reply brief or in a merit brief that she failed to file. And she also failed to argue, as I just mentioned, that it was substantially or procedurally unconscionable, which would be a basis to rule an arbitration provision unenforceable.
Well, it'd be a reason to have a hearing on it.
Correct. But she didn't even bring up that argument. She's not even arguing, which further enhances her agreeance to arbitrate these claims. And
Counsel, I'm just going to put a hypothetical question to you. Do you feel that the court has the right to enforce an illegal agreement just because the other side doesn't object to it?
no, I don't. But I think this is a valid binding
I
arbitration.
understand, I'm just saying a hypothetical one.
No.
I do see that it's actually stamped motion denied.
Yeah,
right?
so they did deny the motion.
And then the words premature are written.
Correct. And I think that was their reasoning behind it.
Thank you.
But this court in Krause v. LaGrange, where a homeowner sued a builder for negligent construction, breach of contract, in that case, they argued that the arbitration provision was substantially and procedurally unconscionable. And the court found that there was that it was not procedurally unconscionable, and that there was no unfair bargaining power. There wasn't a contract that was on a take it or leave it basis. And in this instance, this is similar but also different in the sense that the parties argued between that, and the court found that there was no evidence of substantial unconscionability and procedural unconscionability. Here, there's no argument that the arbitration provision is at all substantially or procedurally unconscionable, or that there was unfair bargaining power on Appley's half or the appellant's half. She simply failed to make those arguments. And second, the lease agreement, it's a 4-page lease agreement as well. It's not like the arbitration provision was hidden in smaller language inside a 50-page lease agreement. It was directly on the last page, right beneath or right above where where the appellee signed her name. And so it's in the same fine print as the whole rest of the lease. And the simple fact of the matter here in this case is, had she wanted to argue that the case not go to arbitration, she had the ability to do that by preparing a reply to our motion to dismiss, or in the alternative, transfer arbitration, or as well, file a merit brief and have the ability to come here and argue the case, but she simply failed to do that. And because of that, like as I mentioned earlier, it further enhances her agreement to arbitrate the claims, because it's not in dispute that the arbitration provision is unenforceable and invalid. And had she wanted to make those arguments, she would have done so in a motion, in a brief in opposition and a merit brief that she failed to file. And for those reasons, we ask that the court reverse and compel.
All right, thank you very much.
Thank you.
For your presentation to the court. We will take the matter under advisement. We will issue a written opinion that will be sent to both sides, as well as we release it on the Ohio Supreme Court website.
Thank you so much.